This video extends the lesson, Day 12, Amsterdam, Delete Personal Data, and contains an in-depth comment related to several GDPR articles, mainly Articles 17 and Article 29 Working Party. Guidelines on the implementation of the Court of Justice of the European Union judgment on Google Spain, and Incorporated v. Agencia Española de Protección de Datos, APD, and Mario Costea González, WP 225. Please, find in the description below references for the course. The so-called right to be forgotten was hailed as a breakthrough in adopting the General Data Protection Regulation, even though it existed in a limited form before. Article 17 provides for a broader right to erasure to consider the exact wording of the provision. European Union residents have a right to ask for the deletion of their personal data. The organization that holds the data has a corresponding obligation to erase them without undue delay under a certain number of circumstances. The significant contribution of this article is proper to have set the conditions for exercising such a right. It exemplifies the grounds on which a person can ask to have her/his data deleted, Recital 65. The article can be invoked if the data are no longer useful for the purpose initially stated, as the name of a person appearing in search engine results and associated with an event of her/his past which is not relevant anymore due to the passage of time, Google Spain SL. It is even possible that initially lawful processing of accurate data may not satisfy the legislation's criteria in the light of the elapsed time since they were processed in the first place, Google Spain SL. The same right belongs to a person who withdrew her/his consent, Article 7(3), or objected right away to the data's processing. Suppose a person gives her/his consent to receive a newsletter from a commercial website. In that case, he can retract the consent, and the website will have to stop processing data associated with the sending of the information letter. Furthermore, a person can invoke her/his right to be forgotten if the processing itself was illegal, meaning that it did not respect the legislation in force, or data had to be erased to comply with statutory obligations. There is one last instance where a person can solicit the deletion of data. It was when they were collected concerning service of the information society offered directly to a child, Article 8. Children enjoy superior protection because they may be less aware of the risks and consequences of sharing their personal information while registering for an online service or using a connected platform, Recital 38. This right should not be taken away from them even if they became adults in the meantime, Recital 65. The right to be forgotten is not absolute. Erasing data on the legal basis mentioned above could result in restraining information available. So, a balance must be struck between the right to a private and family life, guaranteed in Articles 7 and 8 of the Charter of Fundamental Rights of the European Union, and the right to receive information, Article 11. The balance may, however, depend on the nature of the information in question and its sensitivity, and on the interest of the public in having that information, states the Court of Justice of the European Union, Google Spain SL. Article 17, paragraph 3, provides for more exceptions to the right to be forgotten, besides exercising the right to freedom of expression and information, Recitals 65 and 156. Other reasons include compliance with legal obligations or cases where public health is concerned. Data can also be processed for statistical, scientific, or historical research purposes if appropriate safeguards are in place, Article 89. In one last exception, they can be used to establish or exercise a legal claim or to prepare a defense. If European guidelines prescribed that the right to be forgotten should be exercised worldwide, the Court has limited the scope of that right to the European Union territory, Google LLC. The obligation to erase data doesn't extend to all versions of a search engine under the existing EU law. It means that a person may ask to have her/his data deleted from Google.s, Google.fr, and so on, but not from Google.ca or Google.ru. Nonetheless, A national authority may weigh up a person's right to privacy and protect personal data, and the right to freedom of information. After weighing those rights against each other, the national authority may direct the search engine operator to dereference all versions of its service.